that an institution of higher education is not in compliance with this act, the institution of higher education will have 180 days to cure the violation. If the institution of higher education fails to cure the violation, they will be ineligible for funding increases in exceptional items in the following biennium. This amendment amends subsection C of the bill, replacing the existing language with the provision that affirmed the ability of an institution of higher education or their employees to submit a statement to a grant provider or accrediting agency that highlights the institution's work supporting first-generation college students, low-income students, or underserved student populations. Lastly, the amendment allows a student or employee of the institution that is required to participate in DEI, participate in DEI training to bring action against the institution for injunctive or declaratory relief. I'll move passage.
Mr. Speaker.
Ms. Collier, for what purpose?
Will the gentleman yield for questions?
The gentleman yield for questions.
Yes.
Gentleman yields.
Chair Kemple, thank you. Just wanted to go over the part where you said you're removing on page 4, lines 1 through 12, correct? That deals with the governing board of institution of higher education may approve the institution's implementation of a program. You're going to delete that section. Is that correct?
Ms. Collier, will you please repeat that?
Did you say yes?
No, ma'am. Would you please repeat your question?
Sure. On page 4 of the committee of the bill that in front of us before you move passage, page 4, lines 1 through 12, you're deleting that and replacing it with a different provision, correct? I'm looking at page 2 of your amendment.
Page 4, lines
1 through 12.
1 through 12.
And you're going to substitute with this part that says nothing in this section may be construed to limit or prohibit. So you're going to delete the other provision in page 4 that currently exists on lines 1 through 12, correct?
Correct.
Okay, so one of the items in here under your current, on the bill before us, says that the governing board may approve an institution's implementation of a program if the board determines that the program is necessary for the institution to comply with the terms of a grant awarded by our contract with the federal government, a private entity, or nonprofit organization. You are removing that. And so my concern is that there's not going to be coverage for our universities to comply with the terms of
Mrs.
a grant.
Kelly, I understand. We don't think it's necessary. We've applied for grants in the past. This bill maintains requirements already enshrined in federal law, so whatever information universities collect would still be consistent with what the feds require.
Well, it's not only the feds, because in the original it said nonprofits and private entity. They give grants too. So
we would say that it's our understanding that they would applying for those grants would be satisfactory with
a statement.
The statement, yes, ma'am.
Okay.
Faculty research is completely exempt from this bill, so grant funds are unaffected.
Well, it's not just research grants. There's different types of grants that are available to help improve or encourage a diverse population. So my concern here is that we are eliminating funding opportunities for our universities for those types of grants that may require more than a statement. I understand what you're saying is that your understanding is that most grants just require a statement, but how do we have evidence of compliance beyond a statement?
And again, I mean, we could just read the part of the amendment that says for the diversity statement, to apply for it, you know, we can, in our diversity statement, we can say that the institution's work on supporting first generation, low income students, underserved student populations, and certifies compliance with state and federal anti-discrimination laws.
So if there's an audit, which I don't have a problem with the audit part because you're saying that there should be an audit. If the audit reveals that there is no compliance, how do we...
We're just not aware of any grants that...
I know you're not aware, but there's some that exist that may require actual compliance. So what use is it for them to apply if they can't comply?
Understood. We're just not aware of any of those that
Well,
address your question.
that's why we need to be concerned. Because if you're not aware, there may be some that exist, and we may be limiting opportunities for our universities to apply for funding that may rely on certain programs or representations to show evidence of compliance. So I understand you're saying that they just want a statement that says, we agree to promote or look out for, encourage first-generation college students. Yes, that's a statement. But what do you do to show that they are complying with that statement? Is there anything in this?
I just don't have an example, and we think what we've put in the amendment is satisfactory to apply for those grants and ultimately receive them.
Well, you can apply for them, but it doesn't mean that you're complying. Then you have somebody who's not in compliance because they don't have evidence that they've complied beyond a statement. And so this is where I'm concerned that there may be a clawback and our universities have to turn dollars in because they can't prove that they've complied. So I want to know if there's been a contemplation to add to your amendment that they have to comply. If they are awarded a grant, they should be able to comply with the terms of that grant. That's what I'm asking. If that's something, because it was in your original bill. In this one, it was there. There was protections in place. Now they've been removed.
And in conversations with stakeholders and others involved, we do believe that with the language in the amendment, we will be able to satisfy applying to and receiving those grants.
You'll be able to satisfy compliance with the statement?
Applying and in compliance with state and federal anti-discrimination laws.
Okay, so then is it your position that if a private entity or nonprofit has certain requirements in it that deals with increasing diversity at the university through certain programs, that they should not apply for those because it's not aligned with?
Yeah, we love diversity. We don't have a problem with diversity.
I understand that. I understand. Thank you. But in terms of applying for a private entity grant or a nonprofit organization's grant that may require more than a statement to ensure that the goals of that grant are being
We just
fulfilled.
hadn't seen any testimony, anybody suggest that we may not be eligible for those grants.
How would they comply with those? Because it seems like you've eliminated them. No, they're no longer a focus.
Would say that we are not eliminating them.
Well, they're not specifically mentioned in this new amendment that you have. You only say state and federal anti-discrimination laws. You don't say the terms of a grant from a nonprofit or a private entity. So if those grants that help cover gaps in funding that our universities have, if those grants have certain conditions and terms that relate to increasing diversity or increasing population for certain students, are you saying that those universities just shouldn't apply for them because they're not going to be able to show compliance?
No, ma'am. We still believe that with the language in this amendment, will still apply to be able to apply for those grants.
Yes, I understand about applying for them, but it doesn't do them any good if they apply and they can't comply because they don't have anything other than a statement. If I just have a statement that says we support diversity, but I don't show them how I support diversity, then I'm not in compliance.
I think you can show compliance through state law and federal law.
Okay, so help me understand what state law would show compliance.
Number one, first, the anti-discrimination law.
Anti-discrimination laws which protect whom?
Those discriminated against.
Gentleman's time's expired. Members, we are waiting on an amendment to the amendment.